Significance of these guidelines issued after the recommendations by a three-member committee of former Judge Justice R. Basant, Mr. Siddharth Luthra, R. Parameshwaran, and the Constitutional Bench headed by the then Chief Justice, Justice Bobde. We thought that since its latest guidelines having been issued, why not have the insights on these aspects? And Justice Angadi was kind enough to accept our request. And we would request our viewers who are watching us live on the Facebook and YouTube, as well as on this platform, that they should like, subscribe, and comment upon the YouTube channel of Beyond Law CLC, so that we come to know that what type of sessions you are liking it. And during these testing times, the virtual knowledge is the best way to put things forward. Over to you, sir.
Thank you, Sri, because thank you all the viewers. The topic is very interesting. It is very new also. New means in view of the new directions. Exactly 20 days ago, Supreme Court penned down the seven directions in a suo motu writ petition, which it took into consideration. The hard facts of the writ are that 17 long years were spent by the complainant to get fruits of the complaint filed by him under section 138 of the NI Act. That prompted the Supreme Court of India to address various issues which concern the long delay in disposal of the cases under section 138 of the NI Act. As the facts emerge, the Supreme Court stated in body of the order that as on 31/12/2019, there were 2.31 crores of cases pending on the criminal side before various trial courts in the country. Out of that big chunk of 2.31 crores, the complaint under 138 of the NI Act constitutes a major figure, that is 35.16 lakh cases. So 35 lakh cases under NI Act are pending across various trial courts of various states, and they are languishing there for even a number of years. And the apex court, in this case, two checks for rupees 1.75 lakhs were issued by the drawer of the checks in favor of the payee, and those checks were not honored. The check bears the date 27/1/2005, where in 2021, 16 years the complainant was required to wait, and his appeal was taken by the apex court as the suo motu writ petition. There, the apex court laid down 7 important directions, which in fact now assist the law courts, advocates for the complainant, and all the stakeholders to get early disposal of the case in section 138 of the NI Act. And before that, we must have a fair knowledge of provisions of the NI Act and provisions of CRPC also, since they are the one involved in section 138, 139, 142, 143, 148, 148 capital A of the NI Act. I will not take much of the time of the viewers. I know the time constraint, but I must tell you in brief, quickly, various important sections of the NI Act, then followed by a quick pace of versions of CRPC, and then take 7 guidelines, which case laws are good law, which case laws are said as not good law by the apex court. That point we'll take, and we'll take one by one those 7 important facets of the guidelines of the apex court in the above case. So the suo motu writ was disposed of by the apex court exactly 20 days ago. A judgment of 5 judges of the apex court, and the date of order is 16/4/2021. 6 of NI Act defines a check as a bill of exchange drawn on a specified banker and is payable on demand. That is what check means under 6 of the NI Act. 138 speaks of the penal clause for check being issued and not being paid by the drawer of the check to the payee across the counter or through the account of the concerned payee through his concerned banker. So 6 speaks of the word check. Then section 7 speaks of the word drawer, the word drawing. The drawer means the one who draws check, and the word pay means the person to whom the check is payable. Drawing means the name of the banker with whom the drawer maintains his account. Is called as the drawee, or called also as drawee bank. Then section 8 speaks of what's called as holder. 9 speaks of the word holder in due course. Then 10 speaks of payment in due course. A banker, if he makes payment of a check to the holder or holder due course, as per the apparent tenor of the instrument, we speak of what's called as payment by the banker as payment made by it in due course. The banker must not have knowledge that title of the holder is defective. That is the important point. Then 13 speaks of the phrase what that's called as negotiable instrument. It means a promissory note, a bill of exchange, or a check. 14 speaks of negotiation. Then 30 speaks of liability of drawer of a check or a bill, as the case may be, to compensate the holder or payee. So 30 of the Act is linked with section 138 of the Act. 30 says drawer has to make payment of the amount of the check to the payee. 138 says for default by the concerned drawer, the payee can approach the court and get the concerned what you call relief, which is in fact penal in nature. The next point is section 92 of the NI Act. It states of dishonor of a check or instrument by non-payment by the drawer. A drawer of check, issues check, amount is not paid, that's called as check not being honored on account of non-payment. So section 30, section 92, section 93, they go in hand in hand with section 138 of the NI Act. 93 speaks of duty of the drawer of check to give to the duty of the payee to give to the drawer what's called as notice of the fact of the check being dishonored. Then 98 speaks of no notice to be issued of dishonor if the check is countermanded by the drawer of the check. Then comes nextly 118 of the Evidence Act that speaks of the presumptions with a 16 number, and for us, for a check, the important are presumptions as to the date, as to consideration, and then that the holder is a holder in due course. Then comes 138 of the Act that states that when a check is said to be dishonored on account of non-payment by the drawer to the payee, who might have sent the check for collection to his banker, or might go to the bank for payment of the amount across counter if the check is not crossed and with regard to other things. So the point is here, the punishment is up to 2 years or with fine which may be twice the amount of check or both, that is 138 of the NI Act. Then that speaks about the aspect of check being valid for a period of 3 months from date of issue. So the drawer must give the check to the bank for collection or for payment within the period for which the said check is said to be current and valid. Then, then comes the aspect of notice by the drawer, notice by the payee to the drawer informing the fact of check being not honored by the pay bank or by the drawee bank, and it is also the other things which constitutes the offense of section 138 of the NI Act. I will not take much of a time on all those important niceties. Then 141 is offense by company. Implicit there the company also, and also the director or officer responsible for the affairs of the company. And 140 speaks of the aspect that the accused shall not take the defense before the criminal court in the complaint that he had that when the check was issued, it might the check may be dishonored on presentation of the check and for other things. 142 speaks of what's called as time limit for the complainant or the payee to file complaint before the criminal court under section 138 of the Act, and filing complaint before the court of medical magistrate or JMFC as the case may be. So the time limit is within 1 month from the date of arising of the cause of action. And the court can condone delay in fit cases if the complainant could not file complaint within the period of 1 month from the date of accrual of the cause of action. The next point is 142 of the Evidence Act that speaks of a case where the check is delivered for payment to the at a place other than place of the pay, etc. So not very important for us. Then comes the aspect of summary trial of the complaint case by the magistrate court under sections 262 to 265 of the CRPC. Then comes the aspect of conversion of summary trial into summons trial by the magistrate court if the magistrate feels that the facts warrant to inflict punishment more than 1 year. So this point is touched by the apex court in the body of its important guidelines. I will take up the issue there at in detail. So the next point is payment of interim compensation by the court to the complainant pending disposal of the complaint. So any offenses occurring after 1/9/2018, the complainant can move the criminal court for award of what's called as interim compensation, which may be up to 20% of the amount of check, and the court is required to grant the said compensation pending disposal of the main matter. Then comes the aspect of delivery of summons to be served by the court on the accused or drawer by speed post or by courier or other modes of delivery. And 145 speaks of evidence of complaint or affidavit is equal to the court recording evidence of the complainant physically in the open court. So affidavit evidence can be taken into account by the court, and for that the accused or his counsel will cross-examine the said complainant. 146 speaks of bank's slip or memo as prima facie evidence of the factum of the check being dishonored. 147 speaks of the offense being compoundable. The court can permit the parties, the complainant, and the drawer to compound or compromise the offense, and by paying the amount of check with interest and cost as the case may be. 148 speaks of appellate court in case of order of conviction suffered by the concerned drawer of check to direct him to deposit 20% of the amount of fine or compensation for grant of order of suspension or stay of order of conviction of the trial court. This is a new provision which came into force on 1/9/2018. So with that, regarding CRPC, the important provisions are section 2, suppose D of the CRPC that speaks of complaint. Complaint means any allegations made orally or made in writing to a magistrate stating commission of an offense, but not including a police report or a final report or a challan under section 173 of the CRPC. Then 2, suppose W of CRPC defines the phrase summons case as a case which is not a warrant case. So simple definition, summons case is a case which is not a warrant case. So what is called as a warrant case? Section 2, X defines the word or phrase warrant case as meaning a case concerning an offense where the court can inflict punishment exceeding 2 years. So 2 years plus up to the aspect of grant of life sentence and also death penalty. That is the aspect of trial of a warrant case. Punishment exceeding 2 years. And the phrase summary case is not defined in the CRPC. So with this, the next point is chapter 15 of CRPC speaks of what's called as complaints to the magistrates, JFC, or magistrate as we call it in common parlance, and 200 speaks of complaint to the magistrate, and the magistrate has to examine the complaint on oath. So here, as per the apex court decision, the court can take affidavit of the complainant, file along with complaint as evidence or as exhibit in chief. 202 speaks of postponement of issuance of process by the magistrate if the accused resides beyond the territorial jurisdiction of the concerned court. X is the accused in a criminal case under 137 Act at a court in Bangalore in Karnataka. And if the case is filed by the complainant, say Delhi, so the court at Delhi, JMC at Delhi or at Delhi shall postpone issuance of process to the accused of Bangalore, and because he has to make proper inquiry, then only take cognizance and issue summons to the accused in case accused resides beyond the place of the jurisdiction of the concerned criminal court. Then 204 speaks of issue of process by magistrate. That is, if the magistrate holds that there is a case made by the complainant for issuance of process or summons to the accused. Then comes 219 of the CRPC that speaks of joinder of charges. So that states that offense of the same type or of same transaction or forming set of the same sequence of events, and if they are within a span of 1 year, then as per 219 of CRPC, we can club 3 offenses within 1 year on account of the same or continuing cause of action in one criminal case. So that is what's called as more if a trial of more than one offense by one court, if one series of acts are so connected together as to form a same transaction. So up to 3, there can be joinder of the causes of actions if they are out of one set or one series of acts, so connected with each other, and they form the link of the same transaction. Then comes what's called as the chapter 24 of the CRPC, not very important. I mean, chapter 20 speaks of summons trial by the magistrates, that is 251 to 259 of the CRPC. So, summons trial, the important procedure, what to follow in case of what's called as, trial by the court under the 138 of the NI Act. So, what is in section 251 of the CRPC up to section 256, the magistrate has to follow in case of trial of case under section 138 of the CRPC, even though under section 260 of the CRPC, it states of a summary trial. So for summary trial also, the court has to follow the same procedure of a summons trial. So with that, the next point is, if the accused states to court that this court has no jurisdiction to try the case on account of the fact that the complaint is barred by time or on account of some other legal issues, then the magistrate has the power under section 322 of the CRPC to send the papers to the CJM or to the concerned magistrate, and that magistrate or CJM will have the power to go further in the matter. So with this brief backdrop, I will take down quickly the 7 guidelines of Supreme Court of India. I told these backdrops because without knowing them, we cannot appreciate properly those 7 important guidelines. So I will tell now, just to begin with, the brief backdrop for the apex court to touch those important aspects and the important issues or factors which the court kept in mind before issuance of 7 directions will be dealt with by me to begin with, and they concern the aspect of service of summons on the accused if more complaints than one are filed by the same complainant against the same accused, and there is service of complaint, service of summons in one complaint case and non-service of summons on the same accused in the remaining 3 or 4 other complaint cases filed by the same complainant. So that's called as the aspect of service of summons on the accused by the medium of court, by post or by courier service or by speed post or service by the police as case may be, if there are more than 1 complaints filed by the same complainant against the same accused and under different checks over a period of time. The second point is how many cases between the same parties the court can club or hear together. That's called as clubbing of cases. As you all know, in a civil trial, a suit filed by the plaintiff for declaration of title, a suit filed by the defendant separately for grant of separate relief of injunction against the same owner of property or somebody else. Normally, the courts, normally those cases will go together and there will be holding of a common trial. So the point is, how many cases of check bounce matters filed by the same complainant on the same accused, they can be joined together for purpose of recovery of common evidence or for taking them on the same date. That is the second point. The third point is nature of trial being summary trial. What about the drawbacks? In what way were to remedy the important loopholes? The fourth point is attachment of bank accounts. The fifth point is section 202 of the CRPC, summons to be issued to the accused staying beyond the limits of the court issuing summons, what safeguards the court must take. The next point is appeals before the Court of Sessions, High Court or Supreme Court of India, whether there is scope for mediation. As you all know, mediation is a form of ADR, that is the civil sphere, whether mediation can be used in the context of what's called as the criminal trial of section 138 of the CRPC. The next point is whether the magistrate has got inherent powers to review or recall the order of issuance of summons or not. As you all know, every court, civil court, has got the inherent power under section 151 of the CPC to recall any order if fresh set of facts are brought before the court. Our court by itself, suo motu, after hearing both sides, can recall the order because of its inherent powers. Our court can also correct under the CPC by invoking section 152 or 153 also. So that is the aspect of civil side, whether the same set of rules can be invoked by the trial courts, the magistrate courts, in the context of issuance of summons by a magistrate or for review of order by the magistrate on the IA filed by the accused, saying that issuance of summons to the accused is not proper and that the court is required to vary or change the said order. So with these important brief points in mind, and these factors led the apex court to dwell upon those 7 guidelines, I'll now start quickly with regard to the aspect of mechanical conversion by the trial courts of summary trials under sections 260 to 265 CRPC into summons trial under CRPC, sections 251 to 258 of CRPC by magistrates for awarding of sentence more than 1 year without recording sufficient reasons was an issue before the apex court. The apex court, in many cases, had the occasion to see the orders of the trial courts, the JMFC, in which the trial court, if it wanted to award sentence more than 1 year, in case of a summary trial, it could not have done it. So the option was for it to convert the summons trial into what's called as a summons trial. To convert summary trial into a summons trial. Summons trial, so that it can award punishment more than 1 year and up to 2 years. So this is the thing which the apex court was disturbed. Many magistrates were not giving sufficient reasons before conversion of summary trial as summons trial under sections 251 to 258 of the CRPC. This is the first point which bothered very much the apex court. The next point is, namely, the court should hold inquiry before issuance of summons to the accused in case the accused resides beyond the limits of the concerned court. Accused residing beyond the territorial limits of the concerned court. In that case, the section 202 and the apex court stated in many cases that the magistrate should hold proper inquiry and pass orders to issue summons to the accused in this 138 matters if the accused resides outside the limits of the concerned state. So, staying at Bengaluru, complaint filed by the Complainant Act at Delhi Court, the case law of the apex court stated that the court should see the facts properly, say everything properly, and then issue summons. In spite of the apex court judgment, many courts were not following the tenor of the apex court order. That point was touched by the apex court in this particular 7 directions. The next point is whether the trial court should record evidence of the complainant, or whether only apparent evidence of the complainant will be enough for the court to go forward. The next point is, that is what's called as whether the magistrate should examine the complainant and record his evidence and then go forward. And the second important, the next point is how many cases of 138 of the Act filed by the same complainant and the same accused over a period of 12 months or 1 year, they can be joined together. They can be clubbed together. Whether clubbing of cases, as in a civil case, is permissible in a criminal case in the context of section 138 of the Act or not. And in this case, the apex court in the case of Vani Agro Enterprises was a state of Gujarat 2019 part 10 SSC Supreme Court Journal page 238 held that there can be consolidation of 4 complaints filed by the same complainant against the same accused. So in this case, the apex court permitted the complainant to join, or it directed the trial court to post all 4 complaints filed by the same complainant against the same accused for 4 different section 138 offences. That is the ruling of the apex court. Whether this ruling is proper or not, the apex court held that the decision of the Supreme Court in Vani Agro case is good law. So we can post 4 cases filed by the same complainant against the same accused over a period of time, and the court shall give same date. In fact, the court can do here what's called as a joint trial or clubbing of all those 4 cases together. So saving of time, saving of manpower, saving of time of advocates for both sides, the court also and the other stakeholders. The next point is, out of 4 cases, in 1 case only, the summons to admit is served. Remaining 3 cases, summons to the same accused are not served. How to go forward? Unless the remaining 3 cases summons are served, they cannot go forward. So the apex court evolved the concept of deemed service. Whether service of summons by the same complainant against the accused in case 1 is equal to deemed service of the summons on the same accused in the remaining three cases. So the apex court evolved what's called as deemed service and held and gave directions saying that yes, there can be deemed service, no need for the court to issue a fresh summons to the same accused in case 2, case 3 or case 4 if the complaint is filed by the same complainant. The next point is whether the magistrate had the power to recall the order of issuance of process by him to the accused under section 138 of the Act. Whether the magistrate in a given case, he takes on record complaint of the complainant and he issues summons to the accused. Yes, you appear before the court and then you have your defense. So, and the accused appears and files application, recall the order on the ground that you have no power to issue to me the summons. So whether the criminal courts have got the power of recall or power of review, which is available to the civil courts under section 151 of the CRPC. So the apex court in this case touched the aspect in the body of the order. And the apex court in this case held that its decision in the case of K.M. Matthew versus State of Kerala, reported in 1992, Part 1, SCC 217 as not laying down good law. The apex court held that the decision of the apex court in K.M. Matthew versus State of Kerala, reported in 1992, Part 1, SCC, page number 217, is not good law, as not laying down the correct law. So in that case, the apex court held that yes, criminal courts have got the power to recall the order of issuance of summons. It has got the power of review. This order, the apex court, in this judgment of 3 weeks old, held that judgment as not good in law. So a magistrate has no power to recall the summons, review his order issued by him under 138 of the Act to the accused. Accused can challenge the order only before the High Court under Section 482 of the CRPC. So this point the Apex Court dealt with. The next point is whether the criminal court has got the power to stop proceedings under Section 258 of the CRPC. The accused appears before the court and he says, yes, sir, I will pay the amount of check. He says, I will pay the interest amount also. Whether the court can stop proceedings under Section 258 of CRPC. In this case, the Apex Court held that it cannot stop. The Apex Court held that its decision in the case of meters and instruments private limited versus Kanchana Mehta reported in 2018 part 1 SCC 580 as not laying good law. My point is a decision of 2 years, edition of only 2018, the Apex Court held in this case of 16th of April that the ratio in that case is not good in law. The ratio in meters and instruments private limited versus Kanchana Mehta 2018 part 1 SCC page number 580 is set by the Apex Court as not laying good law. So here the Apex Court held that court cannot stop proceedings under Section 258 CRPC in case of complaints under Section 138 of the Act. The other point which the Apex Court evolved was that the judgment of the Apex Court in Adalat Prasad versus Ruplal Jindal, that is 2004 part 7 SCC page number 338, and Subramaniam Sentu Raman versus State of Maharashtra, that is 2004 part 13 SCC page number 324. They do not require reconsideration. The Apex Court held that judgments in the case of Adalat Prasad and the second case is Subramaniam Setu Raman, they laid on proper precedent, proper state of law. They do not require review or recall. So that is, the point is, the trial court has no power to recall the order of issuance of summons by the court to the accused. That power is there only within the High Court under Section 482 of the CRPC, that is decision in Adalat Prasad case and Subramaniam Seturaman case. The next point which the Apex Court touched was that the court, magistrate court, has the power to stay proceedings before it under Section 322 of the CRPC. In case of this complaint case of 138 of Act, if the accused appears and informs the court that it does not have the jurisdiction to try the case, and in that case, court has the power to stay its proceedings because the power of the court to try the case is at stake. So the Apex Court, with the above backdrops, submitted at the end that the appellate courts, that is Court of Sessions, the High Courts and Supreme Court of India, can involve or start the process of settlement by means of mediation. So mediation process, the Appellate Court held that the Court of Sessions, the High Courts and the Appellate Court can make use of to see that there is disposal of more number of cases under Section 138 of the Act. So with all these important backdrops, I will now take quickly those 7 guidelines. I have made my task now very simple and easy. I given you all the backdrop. The first point is before conversion of a case from summary to summons case, a magistrate before recording order, before conversion of trial of complaints from summary to summons case or summons trial should record reasons. So a magistrate under section 138 of the NI Act should give reasons before converting trial of a complaints case under 138 of the NI Act from summary trial under section 260 to TO2 260 of CRPC to what's called as a summons trial under sections 251 to 258 of the CRPC. That is the first important point. Any magistrate, we wants to award punishment more than 1 year, and if wants to switch on the trial from summary to summons trial, then the magistrate shall give invariably reasons to switch off the case from the summary to what's called as a summons trial under sections 251 to 258 of the CRPC. This is the first guideline. So trial courts are now required to give proper reasons. They cannot just say in a one-line order, yes, I want to impose punishment more than 1 year, so I convert the trial as a summons trial. They must now give or spell out proper reasons for conversion of a case from summary to what's called as a summons trial under sections 251 to 258 of CRPC. The second guideline is namely what's called as in any case where the accused resides beyond the territorial limits of the concerned court which issues summons to the accused staying at a place beyond the limits of the concerned court, then the second guideline states that the court shall invariably give proper reasons before issuance of summons by it to the accused under 138 of an act if he resides in some other place beyond the place of location of the court issuing summons. So a party staying at Bangalore, case filed before a court at Delhi. So the example is like that. So in that case, so Delhi court for issuing the summons to the accused at Bangalore shall record reasons before issuing summons to the accused who is staying at Bangalore now. So the apex court in this case took the point, that is the ratio in the case of Birla Corporation Limited versus Advance Investments and Holdings Limited 2019 part 16 SCC page number 610. In that case, the apex court held that the word cognizance used in the CRPC section 200 means the court taking judicially a fact or a fact in a view to initiate proceedings. So the apex court in the case of Birla Corporation Limited held that court must apply a mind before it issues summons to the accused. And in case of the accused residing outside the limits of the concerned court, then court has got one more step, one more added what you call limitation. It shall record reasons before the court issues summons to the accused residing beyond its territorial limits. So the apex court took note of the decision in Birla Corporation Limited 2019 part 16 SCC page number 610, and here the court held that court must go through the records properly and then go forward before issuing summons to the accused residing outside its limits. To prevent innocent accused persons from harassment at the hands of unscrupulous complainants in the false complaints. So to see that false complaints are nipped in the bud, the best court laid down the ratio as per the second guideline. In the above case, court must give reasons, court must see all the records properly, more so if the accused resides beyond the limits of the locality of the concerned court. The appeals court further held in the above case that the appeals court there further held that in the case of Abhijit Pawar versus Hemant Madhukar Nimbalkar 2017 Part 3 SCC page number 528, there the appeals court held that under section 202 of the CRPC, the court shall apply mind and hold inquiry before issuing summons to the accused residing outside its jurisdiction. So, Abhijit Pawar versus Hemant Madhukar Nimbalkar 2017 Part 3 SCC page number 528, the appeals court held that inquiry means proper applying of mind by the court before issuance of summons to the accused. That is, the purpose is to see that false complaints are nipped in the bud and that the accused staying at far off places are not troubled by issuance of summons by the court mechanically. That is the spirit of the judgment in Abhijit Pawar. This case ratio the appeals court made us of in the body of the important guideline. The appeals court held also that its decision in the case of K.S. Joseph versus Philips Carbon Black Limited 2016 Part 11 SCC page number 105 is not good law. Appeals court held that decision in K.S. Joseph versus Philips Carbon Black Limited 2016 Part 11 SCC page number 105. There, the concerned citation stated that the ratio in the case the appeals court held as bad in law. The appeals court also held that a decision in Vidya Dhanuka versus Najima Mamtaj 2014 Part 14 SCC page number 638 to the effect that the word shall in section 202 clause 1 of CRPC prima facie makes the inquiry or investigation as the case may be by the magistrate mandatory. So the court added that purpose of amendment of section 202 was essential as false complaints are filed against persons residing at far off places and to harass them. So the guideline stated the court shall apply mind properly and record reasons for issuing of summons to the accused who reside outside the limits of the concerned court. So with that, the next important point is namely for recall of the summons, for recall of process by the criminal court to the accused can move the High Court under section 482 of CRPC, but he cannot move the magistrate court. The third guideline is namely the court can take into account the affidavit evidence of the complainant as his examination in chief. So the third guideline is for conduct of inquiry under section 202 of CRPC, evidence of the witnesses on behalf of the complainant shall be taken on affidavit. So the appeals court held that the magistrates should not insist for recording of evidence of the complainant or witnesses physically, and they can just give their affidavit evidence and subject themselves for cross-examination by advocate for the accused. So, Article 18, Rule 4 of CPC states that the court did not record the chief of the witness and the court can now take what's called as adjutant chief under Order 18, Rule 4 CPC. The same analogy is made use of by the apex court in the above case. So the fourth guideline is proposed amendment to section 219 of the CRPC. The apex court held in the above case by giving the fourth guideline, saying that there should be amendment to section 219 of the CRPC of one trial against a person for multiple offences under section 138 of the NI Act, committed within a span of 1 year or 12 months, in spite of the limitations under section 219 of the CRPC. The apex court laid down the fourth guideline, saying that for multiple offences between the same parties, same complainant, same accused, for a period of 12 months, there shall be one trial but not separate trials, and there is need to what's called as amend section 209 of the CRPC. That is the what you call fourth guideline of the apex court. The apex court in the case of Balbir versus State of Haryana, that is 2000 SCC, page number 285, Supreme Court held that under section 219 and 220 of the CRPC, if there are several offences as part of the same transaction, and if they are linked with one another in point of time, purpose, cause, and effect, or as principal and subsidiary, then we can say that there is one continuous action, even though different offences might have been committed by the said persons. The fifth guideline is what's called as to treat summons served in one case on the accused as deemed service on the remaining complaints filed by the same complainant as the same accused under sections 138 of the NI Act. Say there are 4 complaints filed by the same complainant X as the same accused Y. In the first case, the summons to accused is served. Case number 2, 3, and 4, summons is not served. Then the fifth guideline stated that to treat service of summons in one complaint case under 138, forming part of a transaction as deemed service for all the remaining complaints filed before it, the same court concerning check bounce under section 138 of the NI Act as part of the same transaction. So no need for the accused, no need for the complainant to take fresh steps against accused in case 2, case 3, or case 4. Summons served in first case is said to be taken as deemed service for case 2, case 3, case 4, if the respondent, if the accused is common and the complainant is common. The sixth guideline is that is a trial court or a magistrate court has no inherent power to review or recall its order of issuance of process. That is the sixth important guideline. The criminal courts have no power of recall or review of order of issue of summons or process to the accused under section 202 of the CRPC. And that power is there only with the High Court under section 482 of the CRPC. Trial courts have no power of review or recall of order of issuing the summons to the accused, and the only thing which the accused can do is approach High Court and get recalled or quashed the complaint under section 138 of the NI Act. So the apex court held that its decision in Adalat Pasar case and Subramaniam Chetaram case, which I stated just now, Adalat Pasar case is 2004, part 7, SCC, page number 338, and Subramaniam Sundaram, I told the citation. So they lay down good law.
It's
They
5
lay
o'clock.
down proper law. And the next point is a magistrate court has the power of recall or review of order of issuance of summons or process to the accused under section 138 of an act or under any other offences under any other acts or enactments. So in this case, the appeals court held that its decision in the case of K.M. Matthew versus State of Kerala, that is 1992, Part 1, SCC, page number 217, is not laying good law. So, good law is case of Adalat Prasad and Subramaniam Seturam, which I told previously, and the decision in this Matthew case is not good law as told by the apex court as per guideline number 6. The seventh guideline is lastly, we cannot invoke section 258 of the CRPC for complaints under section 138 of the NA Act. The seventh point is 258 of CRPC cannot be applied to complaints under section 138 of the NI Act. So the apex court held that its decision in meters and instruments private limited versus Kanchan Mehta 2018 part 1 SCC page number 560 to the effect that principle of section 258 CRPC will apply and that the court can close the case and discharge the accused if the amount of check is paid with cost and interest is not good law. If the accused pays check, amount of check plus cost plus interest also, the court cannot discharge the accused, and it held that the court cannot stop proceedings under section 258 of CRPC. The apex court held that its ratio in meters and instruments is not good law. So the 7th point states that the court under section 138 of the Act cannot invoke section 258 of the CRPC. That is the 7th guideline of the apex court. So with that, and the apex court order that let there be amendment to the Act which can empower the magistrate courts to recall or review this order, and proposal to amend section 29 of the CRPC to include in one trial cases up to 3 or 4. So that is the amendment sought for by the apex court as per the proposals. So with this, I completed the 7 guidelines of the apex court in the above case, and with this, if you got any doubts or any on or want any other clarification, I request the audience and the other stakeholders who are participating to have what you call interacting session. And the first guideline is to sum up. First guideline is to convert a trial from summary to summons. The court shall record proper reasons. That's the first one. Formerly, all these days, the courts were converting a case summary trial as a summons trial mechanically. So now the point is, court should record reasons. First guideline. Second point is, the court should apply mind before it issues summons to the accused residing beyond its territorial limits. The court shall apply mind properly, hold proper inquiry, more so in case of an accused who is residing beyond the limits of the concerned court. That is the second important guideline. The third guideline is, namely, court can take evidence affidavit of the complainant. Court did not insist for recording of evidence of complainant or witnesses. the court can just take directly cross-examination of the complainant or witnesses by the advocate for the accused, as the case may be. So, to make use of the complainant's affidavit evidence or affidavit evidence of the witnesses as the evidence on record, as if the court has recorded it by itself. The fourth guideline is Amendment to Section 209 of CRPC to club 3 or 4 offences by the same accused, and the complaint is common for the purpose of one common trial. So there are 4 complaint cases over a period of 1 year. The CRPC does not provide for clubbing of all those 4 cases, and the first court held that amendment to the CRPC, so that in 1 year, if we have got 4 or 5 check bound cases, same parties are there, then we will try together, and the court can pass a common judgment or a common order. But now we have got the case law of the first court, which permitted that we can have trial up to 4 cases. Court can post them on a common date and dispose of them by what's called as a separate judgment. The fifth guideline is namely what's called as deemed service. In the first case, summons served. Case number 2, 3, 4 of same accused, not served. To take service of summons of first case as deemed service for case number 2, 3, and 4. The sixth point is no power is for the criminal court to recall or review its order of issuance of summons or pursuant to the accused. That is the sixth point. The seventh point is the court cannot stop proceedings under section 258 of CRPC, and judgment in meters and instruments case is set as bad in law. So with this, we will now take up any queries of the audience. The audience are drawn from advocates, plus students of law colleges, and even some of the judges of trial courts. They might have also logged in, and this is a live topic, and I thought that we could have a proper discussion, so that if we are not aware properly the niceties, so following these guidelines by the courts will help in disposal of cases at a fast pace. And for the appellate courts, they can invoke the medium of mediation. So this is a new, what you call, thinking in the aspect of criminal law. We speak of mediation in the context of a family court matter, in the context of a civil matter, but mediation as a mode of ADR under CPC is sought to be made use of by the appellate courts, that is Court of Sessions, High Courts, and the Supreme Court of India. Yes.
The session, as usual, where we have all had sessions with you, they have always been to the point and very illustrative and exhaustive. And more so once we have taken on the topic, which just came, as you rightly said, way back only on 20 days ago. Before we take one question, we will ask Mr. Prem, who's from Kerala, what insights, like the previous session we were discussing about the Aladu Prasad and recalling powers, as to where it can be done or it cannot be done. One, I will ask Prem also, when we say that there is no power of recall, do we say it is akin to the power of what we can say in the normal parlance? Does the court become a functus officio, just what we a common parlance used under the labor code? What is your take on that, Prem?
Well, I would say that any court, irrespective of whether it is civil or criminal, have the power to recall its order. Because if you closely read the maxim actus curiae nimium gravabit, which means that an act of court shall prejudice no man. So if the court does say wrong, the court has to undo the wrong. See, of course, Adalat Prasad and Subramaniam Sheturaman, both of 2004, which again was followed in Dhariwal of 2009, which of course have been held by this constitutional bench as good law. See, it merely dealt with K.M. Matthew, where the court of issuance of the summons and issuance of the summons, that itself was sought to be recalled. That could not be done like that. But if it was a case of fraudulent issuance of summons, then of course the court is, because it was confined merely to one question. T.M. Matthew was confined merely to one question. Whether you can recall the summons, whether the magistrate himself who issues the summons can recall it or not. And kindly see, Adalat Prasad first said that the only option is under 482, which again goes on to get reiterated in Sethuraman. Now kindly see, both these judgments did not consider the matter that a summoning order is a revisable order. It is not a mere interlocutory order. Instead of 482, the accused is having the option under 397 because CRPC provides for that. Even a plethora of Supreme Court judgments also. So that is my take on this recalling. So kindly see, this particular judgment with which we are now dealing with in this particular topic or in this particular talk, I would say, you can see it is alarmed by the inundation of trial courts with lakhs and lakhs of check dishonor cases. This constitutional bench, headed by Chief Justice Bobde, issued a slew of directions, that is 7 directions, on this suo motu writ regarding expeditious disposal of cases under 138 of the NIA. Absolutely true. It is a highly, highly welcome step. But sir, I have a few doubts in the sense, you read the judgment, please see that the court was first concerned with a special leave petition regarding dishonor of checks, which was pertaining to around say 16 years pendency. And then the court takes up a suo motu writ petition merely to consider certain aspects, appoints an amicus curiae, and then comes back with a judgment. Now, earlier it was a 3-judge bench which was dealing with this particular matter. Then the 3-judge bench, they felt the necessity for having a larger bench to deal with certain issues. A 5-judge constitutional bench was constituted, which has given us certain guidelines, 7 in numbers. And kindly see, after this particular 7 guidelines, the Supreme Court immediately goes on to say that this matter is not finally heard, and further hearing of this matter will be before a 3-judge bench. After the guidelines, the Supreme Court is saying, please list this matter after 8 weeks, and further hearing would be after, before a 3-judge bench. So my first question is whether this is an interim order or not. Then my second question would be, of course, it's a highly welcome step, no doubt regarding that. Now the court would say that affidavit evidences suffice at the initial stage. Kindly see, sir, taking cognizance in this particular thing is by means of 190 clause 1 section 1 subclause A of the CRPC. If you read section 200 of the CRPC, 200 starts with the words, a magistrate taking cognizance, he shall examine the complainant upon oath and the witnesses also, and the substance of that examination, it shall be reduced to writing. Of course, affidavit also is in writing, signed by the complainant and the witnesses. Of course, the affidavit also would be, and also by the magistrate. If it is affidavit evidence, it is not signed by the magistrate. So that will be short circuiting the CRPC. Number 1, for which the Supreme Court does not have the power, in my humble opinion, and going by the plethora of judgments. And kindly see, sir, regarding conversion to summons trial, section 143 of this Negotiable Instruments Act, that was inserted by the Amending Act 55 of 2002, which itself specifically provided that for the trial under 138, section 138, it shall be conducted under section 260 to 265 CRPC. And there is a second proviso to section 143, that if during the course of a summary trial, if it appears to the magistrate that the nature of sentence it's to be imposed, it exceeds a particular period, then the magistrate, and that it is undesirable to try this case summarily, the magistrate has to record the reason. So we don't need a Supreme Court order for that, because 143 second proviso makes it absolutely clear that the magistrate is duty bound. And if you read this particular section I mean, section 260 and 261 of the CRPC also, it is there in the CRPC. Because what vexes my mind is, see, Supreme Court itself in Prakashnath Khanna, that's a 2004 9 SEC 686. The Supreme Court goes on to say that if the language employed in a statute, because that is the determinative factor of the legislative intent, the court cannot correct or make up any deficiency in that language. That is what the Supreme Court holds. Then comes another Supreme Court judgment, Delhi Financial Corporation's case, 2004 11 SEC 625, reiterating this position. Then 2004 6 SEC page 210 says when the legislative intent is clear, then the court is duty bound to give effect to each and every word which is used by the legislature. We have a plethora of precedents. And sir, there is a constitution bench decision which dates back to 1950. That is the decision in Keshav Chandra Mandal's case, AR 1950 Supreme Court 265. Because here the Supreme Court was concerned with the hardship factor. The constitution bench early during 1950 goes on to say that hardship or inconvenience cannot alter the meaning of the language employed by the legislature if such meaning is very clear on the very face of the statute. And of course, we have a plethora, a line of judgments which would say that it is for the legislature to amend the law and not for the court. And the court cannot legislate under the garb of interpretation. And the court cannot even seek the legislature to amend laws, because there should be some sort of judicial restraint and the temptation for judicial legislation. It should be eschewed by the courts, says the Supreme Court in a couple of rulings. In fact, judicial legislation, even in the Supreme Court, judgment in 2003, Volume 1, SEC 730, Ginia Keaton's case, the Supreme Court states, in fact, judicial legislation is an oxymoron. This is a word the Supreme Court itself.
I will answer your question one by one, because there is only one-way traffic and we miss the bus where we have to answer. So I have just made one of your points. The first point is, you told that the Apex Court gave guidelines. At the end, the Apex Court told, let the case go back to the bench of 3 judges. That's your first important attack. There is no full-fledged trial of that concerned writ petition, with the Apex Court took it so moto. But here my point is, the Apex Court laid down the 7 guidelines to be followed by the trial courts under Article 141 of the Constitution. The trial courts are bound. Trial courts have no option. If they just don't follow it, they will be sued for contempt. So Article 141 of the Constitution comes into play. So these guidelines, the trial courts shall follow invariably. There's a question of choice. There's a question of any element saying that if I like it, I will follow. If not, I will not do it. The second point is para 8 of the last para 8 of subpara 8 of para 24 of the above judgment states that the Apex Court laid down 7 guidelines. I told you already. All the other points which have been raised by the amicus curiae in his preliminary report to the Supreme Court and written submissions and not considered herein, they shall go before the 3-judge bench for hearing. So questions of points of facts, and this 7-point Apex Court laid down guidelines, those points they made minus. The Apex Court held that for other points not covered by us, as per point number 1 to 7, let the matter go back to the 3-judge bench, and that court shall dispose of the complaints under section 138 of recovery of 1.75 lakhs, which was lent by the complainant to the accused 16 years ago. So I am of the opinion that the Apex Court was right in laying down the guidelines 1 to 7. Number 2 is the Apex Court had the power to send the case to the 3-judge bench to hear and dispose of the main matter, the main appeal, and also touch other aspects of the preliminary report given by amicus curiae and also their note of submission in writing. So clause, subpara 8 Our para 24 of judgment of the apex court says in very clear terms. There is no ambiguity at all. But these 7 guidelines we are bound to follow. Why no option? And we cannot say that let the Supreme Court need not venture to the field of the legislators. And see, in many cases, the apex court has stepped in and told that yes, until the law is there, yes, this is the ratio, and we are going to follow. And in many cases, the apex courts, what you call directions, even though there is no specific law, the parliamentarians took it feasible to amend various laws. So we have seen in many cases, say SCST, Prevention of Atrocity Act, Supreme Court judgment came, then they amended SCST PA Act. Then we have got plethora of the legislations concerning Amendment 2, various acts which are offshoots of the judgments of the apex court, laying down what is the ratio to be governed for the concerned cases to be tried by the trial courts. And we cannot just keep aside judgment of apex court in the case of Adalat Prasad 2004 part 7 SSCC page number 338, and also Subramaniam Sethuram versus State of Maharashtra 2004 part 13 SSCC 324, since the apex court held in body of the order, same order, that they do not warrant any reconsideration. Apex court told power of review, power of recall of summons by a magistrate to the accused, that power is not there for a magistrate. A magistrate cannot recall the order of issuance of summons. Magistrate cannot review his order of issuance of summons even by chance, by mistake. The remedy is approach the High Court only under section 482 of the CRPC. So in those 2 rulings, they have not told that the aggrieved person, the accused, can move a sessions court under section 387 of the CRPC. So these 2 laws, these 2 cases are set by the apex court as being good law, and they require no reconsideration. The apex court also held that decision is not there. The apex court held that trial court cannot be conferred with inherent powers to review or recall the order. But they are given a rider. If the court has no jurisdiction and the accused just court that you have no jurisdiction, then the apex court told court can invoke section 322 of CRPC and stay proceedings, send records to CJM or to the court having jurisdiction. That important step the apex court stated in the body of the very order. And my important point is, we cannot do anything beyond following the precedent of the apex court laid down in a given case. And if the facts, and here, these 7 guidelines, we have no option. We cannot say that for our facts, these guidelines have no application. So the guidelines are there, and they have also proposed for Amendment 2, Section 219 of the CRPC, that have also proposed, and they have also sought for proposal to amend other aspects of the CRPC also. I'm very sure that, see, in fact, you just touched important points, but we cannot go behind the orders of the apex court, which the apex court noted in the body of this order, saying which are cases laying down good law, which are cases not laying good law. And the apex court held that judgment in K.M. Matthew versus State of Kerala, that is 1992, Part 1, SCC page number 217, which stated that the criminal court have got the power of review or recall of order, is said by apex court in this judgment only as not good law. So with this, I think nowadays 5/20/25, I think I made clear to our friend Mr. Menon from Kerala, but he had very nice points to submit because he touched various facets. But for us, the what you call scope is very narrow. Say about 7 guidelines, say which is good law, they say which is not good law, as told by apex court in the body of this judgment. And this is a very short judgment and consisting of as many as 26 paragraphs, and only para number 24 is important. There they have given these 7 guidelines.
This is by Naveen Kumar. Punishment for dishonor of check is up to 2 years as per section 138 of Negotiable Instrument Act.
Yes.
And as per section 260, subclause 1, subclause I, summary trial may be done in such cases. So what is the criteria of converting a summary trial to a summons trial, as punishment is limited to 2 years only, and thus punishment does not seem to be the criteria?
So the apex court, they just order as per point number 1, the high courts are requested to issue practice directions to the magistrates to record reasons before converting trial of complaints under 138 from summary to summons trial. What is called a summary trial? What is called summons trial? I have told you just in the beginning only. So if the magistrate wants to inflict punishment more than 1 year, then he has got the option to switch on from what's called as summary to summons trial under section 251 to 259 of the CRPC. And for that, the apex court told that the court shall record reasons as to why it wants to award to the accused higher punishment more than 1 year and switch on to the what you call summons trial and not resort to the summary trial with which it had started. So that is the aspect of the first important point. And the apex court had told in many cases for conversion of the trial from summary to summons, there shall be order in writing saying or stating reasons, but still that ratio was not followed by many courts. And instead of what you call taking steps of contempt, the apex court in this case laid down. It is a case of a larger bench of 5 judges. They laid down once again the very same ratio, saying that high courts are requested to show practice directions to the magistrates, saying that record reasons before conversion of a case from summons, a summary to summons trial under the CRPC. So court can award punishment more than 1 year if it switches on from the previous set of what's called a summary trial to a summons trial. But I have got one area of what you call lacuna in the NI Act. 138 of the NI Act speaks of punishment up to 2 years, and court can levy a fine which is double the amount of check, 138. Whereas the same provisions of the NI Act, section 143, subclause 1 states that court has to follow what's called as the trial, the trial which is called as a summary trial, subclause 1. And the first clause says, provided that in case of any conviction of in a summary trial under this section, it shall be lawful for the magistrate to pass a sentence of imprisonment for a term not exceeding 1 year. Up to 1 year, court can award punishment in case he holds what is called as a summary trial. And the second clause says, if the magistrate wants to give punishment more than 1 year, as per second proviso to 146+1 of the CRP of the NI Act, it states that the magistrate shall record reasons to convert summary trial as the summons trial to inflict punishment of 2 years. So here the word is shall is there, that's correct. But still, the apex court thought that the trial courts are not following the spirit of the statute, and they just put it in the form of what you call the first guideline in the particular para 24 of the judgment. So my point is 138 speaks of punishment up to 2 years, fine being double amount of check. 143 speaks of punishment up to 1 year in case of summary trial. And for summons trial, the court can levy punishment up to what's called 2 years. So why is it need for the NI Act to have in place 138 and 143 subclause 1 and the two provisos, and they to go hand in hand and to subtract this anomaly? the Supreme Court laid down the first guideline. This anomaly was there. To subtract the anomaly, in my opinion, they just directed the magistrates to record reasons before conversion of complaints under 138 from summary trial to summons trial.
Yes, sir.
Yes, because I think I made myself clear.
I don't think we have any question as such. And tomorrow we would be having a session on a basic, not even as such connected with law as such, but primarily for the purposes of students who are doing law. Because a lot of people feel that what should be the perspective of having internship and whether it helps in the placements. So tomorrow the session would be internships and significances in placement. That is by Aruna L and CA Anish Day. So they will be giving the insights tomorrow. Do stay connected with us at 4:30 p.m. 4 p.m. Thank you, everyone. And thank you on behalf of all those participants who have been watching us live on the Facebook, YouTube, and on this platform. And do like, subscribe, and share our YouTube channel of Beyond Law CLC. Thank you, everyone. Stay safe, stay blessed. And I would request that one should wear the mask and also maintain the social distancing, keeping in with the COVID cases. Thank you. Sir, namaskar. Thank you, everyone.
So thank you, Sri Vikas. Thank you, all the viewers. For me also, it made me to go through in detail the 7 guidelines, and I will share to Vikas a brief note which I prepared of the 7 guidelines with all the case laws of the Apex Court.
Yes,
I
sir.
will just share to him, and he can in turn.
We will share it on our WhatsApp group.
Yeah, I will just because I have prepared in depth. I spent more time, and let it be with you. You can just share to the concerned advocates or anybody who is interested.
That's why we say that they should connect on our WhatsApp group of Beyond Law CLC so that they can get all the notes, whatever the speaker shares. Thank you, everyone.
And one more point which I want to say, the Apex Court the Apex Court about 2 weeks ago gave 16 directions to the trial courts in early disposal of cases pending execution before the civil courts. So they are given 16 guidelines. The Apex Court has dated 22/4. That is just 2 weeks old judgment. They are given 16 directions. So let on this topic somebody should develop on, and that will also sharpen the minds of the courts, the advocates, to see that early fruits of decree is received by the decree holder. So that Sri Vikas also can think over on this point also. Let there be a good webinar. So thank you, Sri Vikas. Thank you all the audience. Namaste.
Namaste.
Yeah.